What's up, everybody? What's up? It's your girl, Legal Beast. I'm just coming from doing a jail visit in Oakland County Jail, of all places, and now I am about to head home. Well, actually, yeah, I'm gonna head home and go from there. I have a very, very busy day tomorrow. I'm gonna be in all things funny. I'm gonna be in Oakland County Circuit Court all day tomorrow. And speaking of Oakland County Circuit Court, I have finally finished the closing from defense counsel Shannon Smith. I don't even know what to say about it, but let me phrase that. I got plenty to say about it, and you know I do, because I've had a lot to say about everything, so we gonna get into it. So, for those who don't know, wow, my teeth are like really white in the dark, like Colgate, baby, and Guru Nanda. I know, right? That was, and no, I don't. I'm not selling it. I'm not doing any of that. I actually happened to get some from Amazon, and I really like it. But that aside, my name is Attorney Kiana Franglich. I am an attorney in Michigan. I practice in Oakland and I practice in Michigan and in Ohio. I've been practicing almost 15 years. I do criminal, real estate, and family. Criminal is the largest bulk of my practice. And I practice as I was starting to say, I practice in throughout the state, but my office is actually, located in Oakland County, in Southfield in Oakland County, where this case is proceeding. So that's just, who I am. And then let me just give you a little bit of a disclaimer. I am not affiliated with the case at all. I am not an attorney on the case. I do not participate. I have not reviewed any evidence. I have not worked for Shannon Smith. I have not worked for her firm. I have not worked for the prosecutor's office. So this is purely my opinions, my 2 cents off of watching the trial proceed, and my thoughts about it, and my thoughts from the view of as the evidence is being presented, right? Like, I'm making my opinions off of everything that's being admitted in trial, nothing else. And that's that. So, and as a parent also, because I'm a parent of 2 girls. So also as a parent, my youngest is getting into middle school. So, there's always that factor kind of in my brain that I tend to think about a little bit as my girls get older and as they're in school. And so these are my thoughts. Now, just as I was not fond of the prosecutor's closing, and they wound up doing a rebuttal, which I did not think they were going to do based upon the statements from the other prosecutor. I forget his name, sorry. Because it appears that they weren't going to reserve time for a rebuttal. I honestly, I think the rebuttal was better than the closing to a degree. I think there were still some things that could have been addressed, but when you're on closing, you are limited to what has been stated on the other closing, and it is closing argument. Now, my bigger issue comes in where it seemed like Shannon was defending herself more so than her client. I know too much about Shannon now at this point. I know too much about, her communications with her husband regarding her daughter, and, too much. I know too much about the communications with her daughter. I know too much about the communications with her husband. I know entirely too much about, text messages and who's sitting with who at lunch, and, and she still has her Christmas tree up, and all of that for that closing to be as long as it fucking was. I thought, that there was really some meaty shit that could have been thoroughly, in my opinion, mapped out, drawn out, developed for the jury. And you have to take into consideration, instead of a 2-week trial, it did, or a 3-week trial, it wasn't, you know, a 2 or 3 week trial in that respect. There was 7 actual days of trial, and it still was a voluminous amount of discovery. And I believe that with the voluminous amount of discovery, that there should have been more of a, and I'm sure there was a plan. She had her postcards, and, you know, she did review some things. Like, okay, I get it. But there was just so much, like, that closing was, that it should not have been, in my opinion. I felt like she was defending herself on TikTok. I felt like she was defending herself in the court of a public opinion. I felt like she was trying to defend every mother. I felt like she was pinpointing at the wrong text messages that she needed to counteract. For instance, the text messages between her and the other attorney and her freaking client. Like, why are we getting back into these privileged text messages or reading them? And, you know, that is not doing anything for you. Why are you reading that shit? Why are you going into that in such depth? I felt like when it came down to I would not have harped on or reminded anyone that my client took 4 fucking Xanax and had a cocktail. And then she tells us that, you know, it doesn't make you a bad parent to have a cocktail. It doesn't make you a bad parent to have a drink. It doesn't. No, not at all. No one is saying that. However, we don't need to know that sometimes you have a fucking bottle. What is that doing for your client's defense? Like, I think, you know, okay, she wants to throw the husband under the bus now. Okay, cool. But you know what? If that's the case, why didn't I see that theme throughout the trial? So for me, in trial and in even evidentiary hearings, sometimes when I have witnesses, I am focused on a theme of what I'm looking for. I am bringing it to you in opening. I am bringing it to you in my questioning. I am bringing it to you in my closing. And if the blame is going to be on dad, that dad was the negligent parent because he's the one that knew the firearms. He's the one that's familiar with the firearms. He was the one that was supposed to lock it up, etc., you know, then that should have been, like, highlighted throughout, or the lack of evidence showing that Miss Crumbley had anything to do with this firearm. Like, you know, there was going to be some things they were not going to be able to kick out, such as her sharing it on social media, a picture of it. Obviously could not knock that out. That was too relevant of evidence. It was, yes, prejudicial, but you know what? Be careful about what you post. It can come back and bite you in the ass. Then she goes into, you know, she's reading certain text messages, and I'm like, you know, and I think by calling Miss Crumbley a hyper vigilant parent could possibly bite her in the ass, because you're saying she's hyper vigilant and she does this and she does that and she's, you know, ABC, and just as you're saying this, it can easily be argued that a hyper vigilant parent would have taken their child for psychiatric assistance treatment diagnosis when you originally started to get text messages and everything of him saying he's seeing things, he thinks he has a problem. That is what a hyper vigilant parent does. You're leaving it too far open for, you know, for what someone believes a hyper vigilant parent would do. And most people believe that she was not a hyper vigilant parent. And how could she be hyper vigilant? Like you said, because she was the breadwinner. She was the full-time working. She was taking care of horses. She was doing all of these things. And she testified to looking for jobs for a husband. And on top of that was having an affair. Where the hell did the son fit into that? So, like, these are just my thoughts. So, I'm really interested to see how quick a verdict is going to come back. I don't think the verdict is going to take as long as some people might think. I don't think the verdict from the jury is going to, you know, be it.